In this module, we will discuss about the Competition Commission in India. Wide powers given in Section 7, the central government has established a commission called the Competition Commission of India, hereinafter referred to as CCI, with effect from 14 October 2003. This commission shall be a body corporate having perpetual succession and a common seal with power to acquire, hold and dispose of property, both movable and immovable, and to contract. The commission shall sue and be sued by the said name. The head office of the commission is at New Delhi and it can establish offices at other places in India. After studying this chapter, you shall be able to understand the nature and composition of the Competition Commission of India, provisions related to the appointment of Director General and other officers in the office of Director General, provisions related to appointment of secretary, experts, professionals, officers and other employees of the commission, provisions related to the general duties of the commission and appointment of secretary, experts, professionals, officers and other employees of the commission, provisions related to inquiries into combination, reference by the statutory authority to the commission and reference by the commission to the statutory authority, orders by Competition Commission of India after inquiry into anti-competitive agreements and abuse of dominant position and division of enterprise having dominant position, extra territorial jurisdiction of commission and kinds of persons who can appear before the commission, rectification of its own order by commission and execution of orders of commission imposing monetary penalties. We shall now understand the composition of the commission, section 7. The commission shall consist of a chairperson and not less than 2 and not more than 6 other members to be appointed by the central government. The chairperson and other members shall be the whole time members. Next, moving on to the appointment of Director General, etc. section 60. The central government is empowered to appoint a Director General by notification for the purpose of assisting the CCI in conducting inquiry into contravention of any of the provisions of the Competition Act 2002 and for performing such other functions as may be provided under this Act. The number of other additional, joint, deputy and assistant director generals or other officers or employees in the office of the Director General and the manner of their appointment are prescribed. For this purpose, Competition Commission of India number of additional, joint, deputy or assistant director general, etc. rules 2009 have been notified. Every such other officers or employees shall exercise functions and powers subject to the general control, supervision and direction of the Director General. The salary, allowances and other terms and conditions of such officers or employees are also prescribed. The Director General, additional, joint, deputy and assistant director generals or other officers or employees are appointed from amongst persons of integrity and outstanding ability who have experience in investigation and knowledge of accountancy, business, public administration and international trade, etc. Now, let us understand the appointment of secretary, experts, professionals, officers and other employees of the Commission, section 70. The CCI is vested with the powers of appointment of a secretary, officers and employees as it considers necessary for the efficient performance of its function under the Act. The salaries, allowances and terms and conditions of services of all such officers and employees have been prescribed by the central government under the rules. For this purpose, Competition Commission of India salary, allowances, other terms and conditions of service of the secretary, etc. Rules 2009 have been notified. The CCI may also engage a number of experts and other professionals of integrity and outstanding ability who have special knowledge of experience in economics, law, business or other disciplines as per the procedure specified by the regulations. For this purpose, Competition Commission of India procedure for engagement of experts and professionals regulations 2009 have been made. We shall now discuss about the duties of Commission section 18. It is the duty of the CCI first to eliminate practices having adverse effect on competition. Second, to endeavour to promote and sustain competition. Third, to protect the interest of consumers. Fourth, to ensure freedom of trade carried on by other participants in market in India. However, subject to prior approval of the central government for the purposes of discharging its duties or promoting its functions under the Act, it may enter into any memorandum or arrangement with any agency of any foreign country. Now let us understand the inquiry into certain agreements and dominant position of enterprise sections 19. The CCI may inquire into any alleged contravention of the provisions of section 3 or section 4. These provisions relate to the anti-competitive agreements and abuse of dominant position of an enterprise or group. Such inquiry can be undertaken by the CCI either on its own motion or in any of the following situations. A. Receipt of any information in such manner and accompanied by prescribed fees from any person, consumer or their associations or trade associations. Or B. A reference made to it by the central government or a state government or a statutory authority. Factors to be considered while considering the adverse effect of an agreement on competition. The CCI, while considering the adverse effect of an agreement on competition, shall take into account the following factors. A. Creation of barriers to new entrants in the market. B. Driving existing competitors out of the market. C. Foreclosure of competition by hindering entry into the market. D. Accrual of benefits to consumers. E. Improvement in production or distribution of goods and provision of services. F. Promotion of technical or scientific and economic development by means of production or distribution of goods or provision of services. Next, factors to be considered by the CCI while inquiring into the dominant position. The CCI, while inquiring into the dominant position of an enterprise or group, shall take into consideration the following factors. A. Market share of the enterprise. B. Size and resources of the enterprise. C. Size and importance of the competitors. D. Economic power of the enterprise including commercial advantages over the competitors. E. Vertical integration of the enterprise or sale or service network of such enterprises. F. Dependence of consumers on the enterprise. G. Monopoly or dominant position whether acquired as a result of any statute or by virtue of being a government company or otherwise. H. Entry barriers including regulatory barriers, financial risk, high capital, cost of entry, marketing entry barriers, technical entry barriers, economies of scale, high cost of substitutable goods or services for consumers. I. Countervailing buying powers. J. Market structure and size of market. K. Social obligations and social cost. L. Relative advantage by way of contribution to the economic development by the enterprise enjoying a dominant position having or likely to have an adverse effect on competition. M. Any other factor which the Commission may consider relevant for the inquiry. Next, Moving on to the inquiry into combination by CCI, section 20. The CCI may initiate inquiry into combination which has caused or is likely to cause an appreciable adverse effect on competition under the following circumstances. First, upon its own knowledge or information relating to acquisition under section 5. Second, acquiring of control under section 5. Third, merger or amalgamation referred to under section 5 of the Act. But the CCI shall not initiate inquiry after the expiry of 1 year from the date on which such combination has taken place. On receipt of notice under section 6 subsection 2 of the Act, the CCI shall initiate inquiry. Next is the factors to be considered by CCI to determine the appreciable adverse effect on competition. For the purpose of determining the appreciable adverse effect on competition in the relevant market, the following factors are required to be considered by the CCI. First, actual and potential level of competition through imports in the market. Second, extent of barriers to entry into the market. Third, level of combination in the market. Fourth, degree of countervailing power in the market. Fifth, likelihoods that the combination would result into the parties being able to significantly and sustainably increase prices or profit margins. Sixth, extent of effective competition likely to sustain in the market. Seventh, extent to which the substitutes are available or are likely to be available in the market. Eighth, market share in the relevant market of the persons or enterprises in a combination individually and as a combination. Ninth, likelihood that the combination would result in the removal of a vigorous and effective competitor or competitors in the market. 10th, nature and extent of vertical integration in the market. 11th, possibility of a failing business. 12th, nature and extent of innovation. 13th, relative advantage by way of the contribution to the economic development by any combination having or likely to have an appreciable adverse effect on competition. 14th, whether the benefits of combination outweigh the adverse impact on competition. Let us now discuss the reference by statutory authority, section 21. A statutory authority may refer an issue to the CCI for its opinion on two cases. First is refer to the CCI by the statutory authority when the issue is raised in the course of proceedings before the statutory authority by a party, and secondly, a statutory authority may suo motu make a reference to the CCI. On receipt of such a reference, the CCI shall give its opinion within 60 days of receipt of such reference to the statutory authority concerned, which shall consider the said opinion and give its findings supported by reasons therefore. We now understand the reference by the Commission, section 21A. If an issue is raised by a party to a proceeding before the CCI that its implementation is entrusted to a statutory authority, the CCI may refer the same to the statutory authority for opinion. The CCI may also suo motu make such a reference to the statutory authority. On receipt of such a reference, the statutory authority shall give its opinion within 60 days of such reference to the CCI, which shall give its findings thereafter with supporting reasons. Now let us understand the orders by CCI after inquiry into anti-competitive agreements and abuse of dominant position, section 27. Where after inquiry the CCI finds that anti-competitive agreements have been made or action of enterprise is in a dominant position, it may pass all or any of the following orders. First, direction to an enterprise or persons or group involved in such agreement or abuse of dominant position to discontinue and not re-enter such agreement or to discontinue such abuse of dominant position. Second, imposition of penalty as it deems fit, which shall not be more than 10% of the average of the turnover for the last 3 preceding financial years upon each of such persons' enterprises which are parties to the agreement or abuse. Where anti-competitive agreement is made by a cartel, the CCI may impose upon each producer, seller or distributor, trader or service provider included in the cartel a penalty of up to 3 times of its profits for each year of the continuance of such agreement or 10% of the turnover for each year of the continuance of each agreement, whichever is higher. Third, direction that the agreement shall stand modified to the extent and in the manner as specified in the order of the CCI. Fourth, direction that the enterprises concerned will abide by such other orders as the CCI may deem fit. While passing the above orders, if the CCI finds that a member of a group is also responsible for such violation, then it may pass orders against such member or members. Next, moving on to the division of enterprise of dominant position, section 28. The CCI may by order in writing or direct division of an enterprise enjoin dominant position to ensure that such enterprise does not abuse its dominant position. Besides, the CCI has power to include all or any of the following matters in its order. First, the transfer or vesting of property, rights or liabilities or obligations. Second, the adjustment of contracts either by discharge or reduction of any liability or obligation or otherwise. Third, the creation or allotment or surrender or cancellation of any shares or stock or securities. Fourth, the formation or winding up of an enterprise or the amendment of memorandum of association or articles of association or any other instrument regulating the business of the enterprise. Fifth, the extent to which and the circumstances in which provisions of the order affecting the enterprise may be altered by the enterprise and the registration thereof. Sixth, any other order which may be necessary to give effect to the division of the enterprise. In any event, an officer of the company who ceases to hold office in consequence of the order of division of the enterprise under the CCI shall not be entitled to claim any compensation for such loss of employment. Now, we shall discuss about the acts taking place out of India but having an effect on competition in India. Section 32. The CCI shall have the power to inquire in accordance with the provisions of section 19, 20, 26 and 30 of the Act into first, anti-competitive agreement or second, abuse of dominant position of an enterprise or third, combination if such agreement or dominant position or combination has or is likely to have an appreciable adverse effect on competition in the relevant market in India and pass necessary orders as per the provisions of the Act under any of the following circumstances. First, an agreement referred to in section 3 of the Act has been entered into out of India. Second, any party to such agreement is out of India. Third, any enterprise abusing the dominant position is out of India. Fourth, a combination has taken place out of India. Fifth, any party to combination is out of India. Sixth, any other matter or practice or action arising out of such agreement or dominant position or combination is out of India. Under section 32, the CCI has the power to pass appropriate orders as it deems fit as per the provisions of the said Act. Moving on to the appearance before the Commission, section 36. A person or an enterprise or the Director General in person or the one authorized by him or chartered accountants or company secretaries or cost accountants or a legal practitioner or any officer of a party may appear before the CCI to present his or its case. We shall now understand rectification of orders passed by the CCI, section 38. The CCI has power to rectify any mistake apparent from the record by amending the order passed by it under the provisions of this Act by following any of the following procedures. First, amendment of the order of its own motion, or second, amendment for rectification of mistake which is brought to its notice by a party to the order. It must be kept in mind that no rectification can be made by the CCI by amending any substantive portion of the order passed under the provision of this Act. Now, let us discuss the execution of the orders of Commission imposing monetary penalties, section 39. If a person fails to pay monetary penalty imposed under this Act, the CCI can recover it as per the provisions of the IT Act 1961 on the reference by the CCI to the appropriate IT authority for recovery of the same as tax due under IT Act. When such reference is made by CCI to the IT authority, the defaulting person shall be deemed to be an arrested in default under the IT Act 1961 as if the provisions of the IT Act were the provisions of the Competition Act 2002 for the purpose of recovery of the monetary penalty imposed under this Act. Let us now recapitulate what we have learned so far. Wide powers given in section 7, the central government has established a commission called the Competition Commission of India, hereinafter referred to as CCI, with effect from 14 October 2003. This commission shall be a body corporate having perpetual succession and a common seal with power to acquire, hold and dispose of property, both movable and immovable, and to contract. The central government is empowered to appoint a Director General by notification for the purpose of assisting the CCI in conducting inquiry into contravention of any of the provisions of the Competition Act 2002 and for performing such other functions as may be provided under this Act. The CCI is vested with the powers of appointment of a secretary, officers and employees as it considers necessary for the efficient performance of its functions under the Act. The salaries, allowances and terms and conditions of services of all such officers and employees have been prescribed by the central government under the rules. On receipt of such a reference, the CCI shall give its opinion within 60 days of receipt of such reference to the statutory authority concerned, which shall consider the said opinion and give its finding supported by reasons therefor. Appearance before the Commission, section 36. A person or an enterprise or the Director General in person or the one authorized by him or chartered accountants or company secretaries or cost accountants or a legal practitioner or any officer of a party may appear before the CCI to present his or its case. Thank you.